34 criminal charges filed in a New York courtroom against a former president of the United States, and the political system is pretending this is just another news cycle, but it isn't. This case has crossed a line that American politics has spent more than 2 centuries carefully avoiding, not because no one ever broke the law before, but because the country understood exactly what happens when criminal accountability and presidential power finally collide in the open. Defiant statements from Donald Trump, quiet panic inside Republican leadership, and calculated silence from figures who understand precisely how dangerous this moment is. What you're about to hear is not speculation, not cable news theater, not partisan fantasy. It is the logical consequence of legal facts colliding with political power under extreme pressure. And once that collision begins, it does not slow down on its own. Stay with me. Because what comes next will not be explained clearly anywhere else, and this is the moment you need to be paying attention. To understand why this matters, we have to start here. The headline, 34 criminal charges, sounds almost routine now, because we have all been trained to absorb Trump headlines the way you absorb weather reports, but these aren't abstract charges. There are 34 counts of falsifying business records in the first degree under New York law, each count tied to specific entries, checks, invoices, and ledger records inside the Trump organization. That's what the indictment actually says, line by line, count by count. And there is a reason this has never been done this way before. America has had corrupt presidents, law-breaking presidents, presidents who lied to the public, presidents who pushed the edges of power until the edges bent. But the modern norm, spoken or unspoken, has been political containment. Let history judge, let voters judge, let institutions quietly protect themselves from the destabilizing effect of a criminal courtroom colliding with presidential gravity. Now that norm is gone, the underlying factual backdrop is also not complicated. The prosecution's theory, as laid out publicly, is that business records were falsified to conceal a scheme related to a hush money payment tied to the 2016 campaign, a $130,000 payment made by Michael Cohen, followed by reimbursements and related documentation that prosecutors say were recorded falsely. Now, here's the critical part. This is not just a New York case. It is a stress test of how a democracy survives when criminal accountability meets mass political loyalty, especially when the defendant is not merely a former president, but a central figure in national power. And after the May 2024 verdict, guilty on all 34 counts, the case didn't end. It moved into an even more volatile phase. Appeals, federal-state friction, and arguments about what evidence is even permissible after the Supreme Court's presidential immunity ruling. You know what makes this moment unusual? The law is doing what the law does, slowly, procedurally, painfully, and politics is demanding speed, dominance, and total loyalty. At what point does this stop being politics? And if you're still treating this like another headline, pay close attention to what happens next. The case began the way state criminal cases usually begin, quietly, procedurally, without drama. A New York grand jury returned an indictment charging 34 felony counts of falsifying business records. Not a vague or sweeping accusation, but a detailed ledger of specific bookkeeping entries, checks, invoices, and vouchers, each one a separate count. This is not the language of politics. It is the language of accounting and criminal law. And then the country did what it always does when Donald Trump appears in an official document. It turned a legal instrument into a political prop. Trump reacted immediately, not through lawyers, but through statements. He called the case smear, a witch hunt, election interference. The familiar language was not meant to persuade a court. It was meant to frame reality for those who follow him. But inside the system, inside courthouses, law offices, and power conference rooms, the tone changed quickly, because everyone understood the practical problem at hand. You cannot process a former president like an ordinary defendant, not because the law says he is different, but because political reality makes it so. And this is the moment when everything began to shift. As the case moved closer to trial, the conversation stopped being about headlines and started being about control. Control of security, control of public messaging, control of institutional legitimacy. Judge Juan Merchan, inside the courtroom, did not raise his voice. He spoke briefly, evenly, repeatedly reminding the parties, the defendant is required to comply with court orders like any other defendant. But that calm itself revealed how abnormal the situation had become. A state judge weighing every word not only for its legal meaning, but for the political consequences that could erupt outside the courtroom. The Manhattan District Attorney's Office had the evidence, the judge had the courtroom, but neither of them controlled what would happen outside those doors, as millions of Americans were repeatedly told that a criminal court was stealing an election. Then the verdict came down, guilty on all 34 counts, not partial, not mixed, all 34. At that moment, Trump did not appear stunned. He shook his head. He stared straight ahead. His face showed no surprise, only the familiar anger of someone who refuses to accept restraint. Outside the courthouse, allies immediately denounced the verdict as illegitimate. But inside the corridors of power, the reaction was far quieter, and that is when the political war room became a literal room. A secure conference space, no press, no phones, aides asked to remain outside. Present were senior congressional leaders. Speaker of the House Mike Johnson, Senate Majority Leader John Thune, and Minority Leaders Hakeem Jeffries and Chuck Schumer, not because they had jurisdiction over a New York prosecution, but because they bore responsibility for whether the country could remain upright when institutions collided. Johnson was cautious. He spoke about the rule of law, but avoided referencing the verdict directly. Thune spoke little, someone counting votes in his head. Schumer was clearer, emphasizing that the jury has spoken, while still avoiding language that could be interpreted as political vengeance. The New York prosecutor was present in person because the threats were no longer rhetorical. A representative of the judge was there because court security had become a constitutional issue, not a logistical one. And the White House counsel's office was present because even the appearance of federal interference could be catastrophic. Someone said calmly, "We need a containment plan." And that is when the language changed, when legal vocabulary replaced political vocabulary, gag orders, appeals, jurisdiction, removal, contempt of court, protective security, credible threats. And here is the most critical part. At the center of the table was a single question no one wanted to say out loud. If a criminal conviction does not weaken Donald Trump's political power, but instead hardens it, what does that say about the balance of self-government in American democracy? Now we need to stop and understand what is actually happening here. For nearly a decade, the American public has been trained, not by law but by intensity, to hear everything involving Donald Trump as a political question. 34 criminal charges. The reflex is immediate. Does this help him or hurt him? Does it energize the base? Who benefits politically? That reflex is conditioned. And that reflex is what causes people to miss the point, because this is not a political question. This is a legal one, narrow, specific, and unforgiving. Start where the law starts. Under New York penal law, per 175.10, falsifying business records becomes a felony not because of sloppy bookkeeping, but because of intent to defraud, and more importantly, that intent must include committing, aiding, or concealing another crime. That is not a technicality. That is the trigger. In other words, if you remove that element, you are no longer talking about this case. You are talking about a more convenient version of it. So when you hear this reduced to paperwork or a bookkeeping dispute, understand what that is. It is not an analysis. It is avoidance, not confusion, choice. And behind that choice is a long-standing American norm, one never written into the Constitution but carefully observed. There is no constitutional provision that exempts presidents, current or former, from state criminal law. What exists instead is institutional restraint, a shared understanding that dragging presidential power into a criminal courtroom could do more harm than good. That norm held for generations, and now it is broken. This indictment is not symbolic, it is not abstract, it is a list, count by count, of alleged falsifications tied to dates, documents, and ledger entries. That is exactly what a grand jury indictment is required to do. Specify conduct clearly enough to be tested in court. So, which argument collapses under even minimal scrutiny? The claim that this is politics dressed up as law. If it were politics, it would not turn on statutory elements this narrow. If it were politics, lawyers would not be fighting over evidentiary boundaries, protective orders, contempt risks, and appellate timing. Politics does not care about those things. Criminal procedure does. And then comes the turning point. On July 1st, 2024, the Supreme Court expanded and complicated presidential immunity doctrine, drawing lines between official and unofficial acts, while leaving a gray zone large enough for any former office holder to exploit. That ruling was not about New York, but it immediately became a tool in Donald Trump's legal strategy. Reclassify as much conduct as possible as official, so that ordinary criminal accountability becomes constitutionally radioactive. And here is the most destabilizing part, not whether he is guilty or not, but what evidence the law will even allow courts to consider when a defendant insists that former power still shields present conduct. You can see that friction in delayed sentencing, in post-trial motions, in the judiciary's caution, as every procedural ruling risks becoming a national flashpoint. So when you hear someone say, "This is unprecedented," understand it properly. That is not melodrama. It is a diagnosis. The legal system is doing what it is designed to do, slowly, precisely, without emotion. The political system is not. And this moment stops being politics when a major party begins treating criminal adjudication, the plain, boring machinery of evidence and verdicts, as illegitimate by definition, simply because it applies to their leader. At that point, we are no longer arguing about Donald Trump. We are arguing about whether law can survive proximity to power. Let's talk about who pays for this, because the first instinct in Washington is always to treat legal chaos as an elite problem. Courtrooms, lawyers, filings, cable panels, fundraising emails. But the downstream effects don't land on the people in suits. They land on ordinary people who just want a government that functions. Here's the immediate consequence. Institutional time gets hijacked. Congressional leadership ends up burning weeks on procedural brinkmanship and security planning, not because Congress has authority over a New York criminal case, but because a criminal case involving Trump pulls the entire system into its gravity field. That means less time for budgets, disaster funding, immigration fixes, veteran services, pick your national backlog, and the public absorbs a quieter consequence, the normalization of legal defiance. When a major political movement tells millions of people that a verdict is illegitimate by definition, you don't just weaken trust in one judge or one prosecutor or one jury. You weaken the basic idea that facts can be adjudicated at all. And once you teach people that, the next step is obvious. Every future case becomes optional, believable only if it flatters your side. Now, this is where it stops being abstract. You see it in local election workers being harassed. You see it in jurors needing protection, courts tightening access, prosecutors receiving credible threats. You see it in the cost. Security budgets rise, public proceedings become harder to run, trials become riskier to hold. That doesn't punish the establishment. It punishes the public's ability to have a functioning justice system. And politically, the incentive structure gets warped. Republican officials who privately concede the legal reality, guilty verdict, proper procedure, feel forced into public performance. Democrats, meanwhile, face their own trap. If they over-celebrate, they look like they're weaponizing the courts. If they underreact, they normalize the breach. So who loses the most? Not Trump, not the donors, not the cable stars. The people who lose first are the ones who rely on predictable institutions. Small businesses needing stable markets, families needing functional services, communities needing credible courts, citizens needing elections they can trust. Don't go anywhere, because the most dangerous part is what this teaches the system to do next time. And ask yourself, what happens when the next crisis is bigger, faster, and doesn't give the country months to argue about it? Pay very close attention to what happens next, because this is the phase where the system's incentives begin to turn toxic. Not loudly, not dramatically, but with a slow, corrosive force. The first likely development is not chaos in the streets. It is procedural escalation. After a guilty verdict, the center of the legal battle is no longer the simple question, did he do it? That question has already been answered by a jury. The new and far more dangerous question is this: does the system have the right to treat him like any other citizen? From here on, motions and appeals will not be designed to win on narrow factual points. They are designed to do something else, to establish a new governing principle, one in which an ordinary criminal process is deemed illegitimate from the outset, simply because it touches presidential power. And the Supreme Court's immunity framework, that whether you support it or oppose it, has handed Trump a new tool: the ability to argue that evidence, context, even witness testimony can be considered constitutionally tainted if it can be linked, however loosely, to conduct related to official duties. That turns the case into a prolonged tug of war. How much the jury was allowed to hear, how much the court was allowed to consider, and how far future prosecutors are permitted to push the boundaries. The second development is just as consequential. Fragmentation within the Republican Party shifts from theory to operational reality. On one side is a faction willing to burn it down, treating the case as proof that the judiciary must be brought under political control. On the other side is a containment faction, those who understand that an open war with courts, juries, and state criminal law is a dead end. But the containment faction will not speak loudly in public. They move quietly, through committee schedules, donor signals, leadership contests, and decisions about which legislation advances and which is quietly stalled. And then comes the part most people miss. This case becomes a template, not a template for prosecuting former presidents, a template for how political movements respond when they lose in court. If the lesson absorbed is, verdicts do not bind us, then the next step is inevitable: selective compliance. Courts become institutions you respect only when you win. And that is the fork in the road before us. Either political leaders on both sides reassert the old democratic boundary, courts decide facts, politics decides policy, or we slide into a new normal where legal outcomes are treated like partisan votes, valid for one side, illegitimate for the other. And at that point, ask yourself a serious question. What happens when a future president faces a genuine national security crisis, a moment that demands instant public trust, while half the country has been trained to reject the legitimacy of any institution that contradicts the story it prefers? This is where the story truly turns, because the next crisis will not announce itself politely. It will arrive fast. It will arrive violently, and it will arrive like a door being kicked in. This is the moment you need to pay attention, because the most important fact in this story is not the number, 34, or even the verdict itself. The most important fact is what the country does with it. A jury heard evidence and returned a decision. A judge applied the procedure. A prosecutor used a statute written long before Donald Trump's name was ever on a ballot. That is not politics. That is the machinery of a legal system doing what it exists to do: decide disputes in a controlled, nonviolent way. And yet, we are watching a major political movement attempt something radically different: to treat law as optional when law becomes inconvenient. At what point does this stop being politics? It stops being politics the moment people in power decide that courts are legitimate only when they are obedient. Because if you normalize that, if you make that the standard, then you don't just change the Trump story, you change the American story. This is why this cannot be waved away as another scandal, another headline, another exhausting week in a country that has learned to live with exhaustion. The question is not whether you like Trump. The question is whether you want a system where criminal accountability exists at all, or whether we are building a precedent where power is its own defense. And here is the line that should stay with you. A democracy does not collapse when a court convicts a powerful man. It collapses when powerful men convince millions of citizens that the court itself is the enemy. That is the danger at this moment.